in this case, we had this example actually happened one time. We had in this case where we insured a lot, and I got a call one day from an office that did a closing, and they said, we did a closing about 3 or 4 months ago. Should we have made an exception for the fact that the neighbor's fence encroaches 40 feet into our property? And I said, well, not only should we have made an exception, better yet, we should have not done the closing, and we should have investigated the matter, looked at the bounding deeds, things like that. And they said, well, we've done that now. And we determined that the owner, the adjacent owner, is claiming that he owns that 40 feet, and his deed does cover it. So in this case, we had an overlap. And they said, what do we do now? And I said, well, now I give you the contact information for the claims department. So overlaps are things that you need to be careful about. Very, very small overlaps, you know, a couple of tenths of a foot or something are usually not problematic, but large overlaps, you need to be very careful. Okay, the next term is the gap. Sometimes it's called a gore or a hiatus. And this is kind of the antithesis of the overlap. This is where the deeds to parcel 1 and parcel 2, neither of those deeds cover this gap area. It's sort of a no man's land in between here. But obviously in the back title, if you go back far enough, somebody has title to that gap. Well, gaps are not usually quite as dangerous because consider the fact that if you're insuring parcel 1 or parcel 2, you're not insuring the gap. So you're not ensuring that anyone has title to that part of the property. But the problem you can come up with is where a gap exists like that, the owner, if that gap is landlocked, and in this example, we don't show where the road is, but if there is no road that abuts the gap, and if the owner has to claim access through our parcel, then we have a claim for access. And if the parcels were ever titled together, then we have a right-of-way by necessity claim that can result. Now, here's another example of a gap that shows that in this case, this owner of this gap may claim access through any one of these parcels as convenient or necessary. The likelihood is if it was titled with one of these parcels in the past, that's probably where they would make their claim. But we could have a claim for access as a result of the gap. So you need to watch out for that. Okay, now a word about constructive service of process and legal descriptions in constructive service. Perhaps a little definitions in order. Service of process is that thing by which, in our system of law, someone who is being sued and their property rights are being put in jeopardy cannot be sued unless they are given an opportunity to come in and defend their suit, to make their arguments before the judge before the court passes judgment. Well, when the way they do this is when they can locate the defendant, they go out and serve a summons, which has a copy of the complaint in it and gives a description of the property and states the nature of the suit. But when the defendant cannot be located, in some types of litigation, the court will permit service of process to be what we call constructive service of process or service of process by publication. And in this case, the plaintiff will file what's called a notice of action in a local newspaper or periodical, and they'll name the defendant and the plaintiff, and they'll give a general description of the type of lawsuit, and they also have to give an adequate legal description. Well, the courts recognize that the likelihood of someone finding out about a lawsuit against them by reading a newspaper is slim to none. So as a result, the courts are very harsh to construe any errors in the legal description in constructive service of process. As a matter of fact, although it's not directly on point, in this case that we've given you here, Brown versus Son, actually the description would have been adequate for a deed. They used the archaic tax roll legal. Brown was being sued for quiet title, and in this case, the legal was something like part lot 3 and 4, recorded deed book page so-and-so, and then it said except part recorded in, it listed like 8 to 10 different book page references. So the court said in that case, Brown wouldn't even know what land this described. So even though it would have been adequate for a deed, believe it or not, it wasn't adequate for constructive service of process. We simply make this point to make a related point, that if there are any errors in that legal and constructive service of process, they're going to be very harshly construed. So those of you who examine litigation files need to be aware of that. Now next we have another kind of a survey review issue here. And this is when a survey is done for a meets and bounds description, where the surveyor determines that a particular call in the description where the elements in the deed, the angle or the distance in the deed, do not match the actual ground measurements that the surveyor makes, then they're required to point that out in the survey. But the way they point it out can be kind of easy to overlook if you're not used to looking for it. In this example, excuse me, in this example, tract A was a platted tract. The road was cut through after the plat. So if you look at the plat, there is no road there at that time. I think the road was further south. But once this road was cut through, someone surmised that the rest of the tract north of the road was 250 feet. So they began to describe the property as the north 250 feet of tract A. Well, in this case, when the surveyor did the survey, it was noticed that that distance from the north line of the road to the north line of the tract was not 250 feet, it was 256 feet. But look how the surveyor noted it on the survey. And this was adequate. This was all the surveyor was required to do. But look at that call on the west line of the blue tract there. It says 250 feet deed, 256 feet measured. Sometimes they'll say 256 feet actual. It's a parenthetical notation. Well, some of you examiners have already seen the bomb that's lying there in the ground on this parcel. If there are 256 feet between the road and the north line of the tract, and we are the north 250, then we fall 6 feet short of the road and we have no access. So in this case, it was a subtle distinction on the survey. It was missed by the person doing the survey read, and a claim resulted from that. So you want to be careful, read the surveyor's notes carefully. A note about boundary line agreements. Sometimes when people have disputes over boundary lines, they will settle their differences in a boundary line agreement. Some things to be careful about when they do that: they should refer to the same survey, because sometimes surveyors can disagree on where points on the ground are, and so they should use one surveyor. Also, the boundary line agreement should contain conveyance language so that each party quitclaims to the other on their respective side of the line. And finally, if there are any existing mortgagees who have mortgages on either parcel, they must join in the agreement, because if you have a boundary line agreement and then later the lender takes title, they're not bound by that agreement. So you're right back where you started from again. Now, another point about surveys quickly and legal descriptions. Sometimes when we have a problem with a legal description, we're not sure it's adequate, or we have boundary line dispute issues or questions, a survey will be required to help sort out some of the problems. You need to be careful when we do that we reserve the right to amend the commitment or make additional requirements upon review of the survey. We had a case one time years ago where an office required a survey, and they required it in the commitment, so the seller went out and got a survey and delivered it to the office and said, okay, I'm ready to close. And we said, no, this just tells us what our problems are. We're going to have agreements or releases or boundary line agreements or whatever. And the customer said, no, your commitment says you want a survey. Here's your survey. I'm ready to close. So you want to be careful. Two things, really: who's going to pay for the survey, and you want to make sure you have a right to reserve to make additional requirements upon review of it. Now, another thing about wild instruments, we have another uniform title standard here. I want to go through this quickly, but we do deal with this a lot.